The testimony that all of you have presented is very interesting testimony and has some conflict as you have heard it. I think probably a starting point is that all of us would agree that Indians, Alaska Natives, Native Hawaiians, and others have suffered great injustices at the hands of the federal government, federal agencies, museums, and other institutions that have removed the remains of their ancestors. And I recall some years ago being involved with respect to the Smithsonian that was warehousing massive amounts of Indian remains in their basements and their warehouses, and I became very interested in that. And I want to tell you one other just story of interest, and it relates only tangentially to this. I was walking down in the hallway of this building about 4 years ago, and I saw a historical document in a little display about Senate history. And it was a historical document about something called the Congressional Cemetery, which really isn't owned by or supported by the Congress, but it's called the Congressional Cemetery. And it's over here just not very far from this building. And it said that there were senators and congressmen buried there from decades past, in the past century. It's also said there were some Indians buried there. And I said to my staff, well, let's find out if there are Indians from our region buried there and why and how it happened. And so I had my staff do some research, and sure enough, there was a man named Scarlet Crow buried there. He's from the Sisseton-Wahpeton tribe, which is partly in North Dakota. And I decided to find out what had happened to Scarlet Crow, and he came out to Washington, D.C. with, I think, 6 or 8 other Indians from his tribe. I believe it was 1862 to negotiate a treaty. And he was found dead under the Occoquan Bridge. And the death certificate said suicide. And they buried him over here in the Congressional Cemetery in a far corner. I got a copy of the Alexandria, Virginia police records and saw that when they investigated the death of Scarlet Crow, this fellow who was in Washington, D.C. from the Wahpeton-Sisseton tribe in the 1860s, when they investigated his death, the investigators, police investigators, said that he was said to have committed suicide by hanging, but in fact, he was lying next to his robe that was carefully folded next to his body, and the branch from which they said he would have hung himself wouldn't have held a 6-year-old child. These are the police investigators. Seems to me it was just a cursory review of whatever records were available. This man was killed, which probably wasn't too unusual back in the 1860s when people from tribes came here, and then he was put in a small grave over here. I've notified the tribe, the Sisseton-Wahpeton tribe, with all the relevant information about this man named Scarlet Crow, who came to Washington, D.C., I'm sure with great intentions with his tribal members of negotiating a treaty with the federal government, and ended up being killed under the Occoquan Bridge. Very unlikely he committed suicide. Very likely he was killed, and the investigation was stopped, and they put suicide on the death certificate and buried him in the corner of the cemetery. And so my acquaintance with all of these issues is not only going over to the Congressional Cemetery and investigating that, but working with the tribe to think through the issue of burial grounds and the building of a bridge, a whole range of issues, working with others in my service in both the House and the Senate with respect to the issue of the Smithsonian and other institutions that picked up remains of Native Americans and warehoused them. This is a very emotional issue, and it's a spiritual issue. And I find it really intellectually interesting, obviously, to hear the different views today. And it's difficult. It's not an easy issue to deal with because you're dealing with spiritual issues here. And so let me ask the question. Let me start with Ms. Barran. Am I pronouncing that correctly?
Yes, you are.
Ms. Barran and Mr. Bender, I'd assumed that you probably knew each other and were long-standing advocates on different sides of this issue. Ms. Barran, you expressed disagreement with Mr. Bender. Let me have Mr. Bender respond to your disagreement, and then let's have a discussion about that. Mr. Bender?
Yeah, the reason we haven't met, I think, is that I have not been an advocate on this issue. My contact with it really stopped when the legislation was approved. I testified before the committee prior to the legislation's enactment in my capacity as a facilitator of the national dialogue. So I have not been involved. My point here was that the Ninth Circuit decision is an erroneous construction of the statute as I understood it at the time it was enacted. And the statute was a compromise, as everybody has said. A couple of things in response to what Ms. Barran said. Scientific people are not excluded from the process of deciding what should be done with unaffiliated remains. The review committee contains 7 members. 3 of them are Indians, and 3 of them are nominated by museums and the scientific community. That is the way the scientific community is guaranteed a consultation with regard to remains that are not connected with a present-day tribe. Those remains are to be disposed of in the way that the review committee says, and the review committee has a very substantial scientific representation. But what the proposal is, what the Ninth Circuit has done, and if you don't change the Ninth Circuit decision, what's going to happen is not that scientists are going to be excluded, but that Indians are going to be excluded from the process, because there are 3 Indians on that committee also. That's the chance of the Indian community to have some say in what should happen to these prehistoric remains that are not affiliated with any current tribe. If the Ninth Circuit decision is correct, Indians will not be involved in that process. And the most important thing that NAGPRA did was to include Indians in the process. For example, when museums are told to do an inventory, this is the inventory section, Section 3003, they're told to do an inventory of Native American things and tell the tribes what they have. If unaffiliated, remains that are unaffiliated with the current tribe are not Native American, they won't even tell the tribes they have them. That's wrong. That is exactly contrary to what everybody at the time wanted NAGPRA to do. It wanted NAGPRA to include Indians in the process, not to exclude them. So that's the basic problem with the Ninth Circuit decision, and reversing the Ninth Circuit decision does not exclude scientists because they are included in the review committee.
Ms. Barran?
As you can see, I'm ready to go here. Let me tell you what that guarantee meant to us 9 years ago, and I think that will give you a sense of why the Ninth Circuit was outraged, why the Federal District Court for the District of Oregon was outraged, and why that court ultimately concluded that the government had acted in bad faith and was consistently biased. 9 years ago, on July 26th, the Kennewick Man skeleton was discovered. His remains were collected by an anthropologist, Dr. Chatters, and Dr. Chatters initially thought that the remains may very well have been a Caucasian settler of the area until he saw the stone spear point in the hip bone of the skeleton, and until an early radiocarbon dating showed that he was incredibly old, 9,000 years old. Dr. Chatters was in immediate consultation with Dr. Owsley at the Smithsonian, who is one of the world's experts in these ancient remains. The Army Corps of Engineers got wind of it, learned of the discovery because Dr. Chatters had to obtain a permit to excavate the remains, and they seized the skeleton. And from that point forward, the government clamped down its lid on everything that was happening. Our clients didn't march into court just because they wanted to get themselves involved in an almost decade-long legal battle. But they started writing letters saying, let me explain what this means. Let me tell you what it means to find an almost complete 9,000-year-old skeleton in this country. And not only were they rebuffed, they barely had an acknowledgement that they had even written. They attempted to discuss this issue with the government, but were closed out. Then the Army Corps of Engineers started creating the documents that we later saw as the administrative record, and I'm going to quote directly from the Army Corps of Engineers. I told him, referring to one of the tribal representatives, we will do what the tribes decide to do with the remains, but that we will not involve ourselves in that decision. I assured him that we are working under the assumption the decision will be what the Umatilla have asked for. One of the claims that we brought ultimately in the Kennewick Man litigation was a denial of due process to our clients. And one of the issues in the court decision was a finding by the federal district court at the trial court level and later affirmed by the Ninth Circuit. Not that it was wrong to consult with the tribes, but that it was wrong to close us out of the process because the skeleton was not Native American to begin with. This is an ancient person from possibly Polynesia who came to these shores. He's not an ancestral to current day tribes. So when we finally concluded at the trial court level, sort of the middle part of this process, the trial court actually wrote that the administrative record from these government agencies, the Army Corps of Engineers and subsequently Department of Interior, establishes that the agency was consistently biased, acted with obvious disregard for even the appearance of neutrality, and predetermined the outcome of critical decisions, including the ultimate disposition of the remains. They jumped to a decision without even knowing what they had. Our battle with the government has never been over an effort to exclude the tribes from this process, but we had an anthropological treasure found in this country, and it was going to go back into the ground without ever allowing us to teach anything.
Ms. Barran, I don't want you to re-argue the case, but I appreciate
Sure.
your comments. Let me ask Mr. Echohawk. And I think from what I've learned from the witnesses, including Ms. Barran, I think that there's a default position assumed in some of the testimony here that human remains should be, shall be, or will be considered tribal, indigenous people as a kind of a default position. And if that's the case, especially with the proposed amendment, if that's the case, then if tomorrow someone finds the remains of a person that was judged to be living 12,000 years ago, a scientific treasure trove of information about human life then, would because of cultural issues and other concerns, would there be a preclusion of the study of those remains?
Not necessarily, Senator. If the amendment goes forward to preserve the original intent of Congress, it would simply mean that that person would be deemed to be a Native American and subject to the provisions of the Act, the input, the consultation, the protective procedures. It would not mandate his repatriation at all, because any tribal claimant would have to establish that it is culturally affiliated with those remains.
Can I just at that moment, just for a second, save your thought. Ms. Barran is saying that in fact consultation was prohibited in the scientific direction by the government agencies. You support consultation in both directions, I assume, and so does Mr. Bender. Is that correct?
Yes.
I'm sorry, let Mr. Echohawk finish, but I just wanted to make that point. The consultation issue is really important in this discussion.
Exactly, and I think it's built into the Act on all sides, and no one is intended to be excluded. Now, I can't comment on the facts of the particular Kennewick case, whether the particular federal officials may have abused or acted improperly with regard to the particular facts of that case, which has nothing to do with the statute or its coverage. And I'm not here today to overturn the outcome of that case, because the court did hold that the tribal claimants were unable to prove their cultural affiliation with those remains. And we're not here today to overturn that outcome, but merely to restore the coverage that everyone thought we had on the statute. And that coverage, in 15 years since the date of NAGPRA, has not emptied our universities. It has not emptied the collections of human remains. For example, you mentioned earlier that at the Smithsonian, in 1989, they had 18,000 remains. Congress enacted repatriation provisions very similar, saying that those that are culturally affiliated could be repatriated. Well, here we are 15 years later, and there are still 15,000 remains in the Smithsonian. So it hasn't emptied the collection, and my fundamental problem with some of what has been said today is I think that the scientific community is overstating some of their fears and concerns, because we simply have not had that experience in the United States of having absurd outcomes under the statute. And we have not emptied, like there's hundreds of thousands of remains that are still on shelves under the statute. And so I think that many of these concerns are overstated and not reflected in our actual experience in 15 years.
Ms. Lambert, if I might ask you, if or was two words were amended to the statute, is it your contention that that would largely preclude you from being consulted, from being a part of this process? Is that what your testimony is?
No.
Okay.
No.
Explain that, if you would.
In fact, we really have no problem with that, but it depends on the regulations for culturally unidentified human remains. And I think one of the interesting things about the Ninth Circuit Court decision is that it showed that a common sense interpretation is not necessarily the same as a legal interpretation. And that we certainly agree with the common sense, and if you look at our literature, you'll find Native American, for those of us who study the past here, everywhere. And so I don't think you'd find agreement at that level. However, when you change statutory language, you change legal ramifications, and what we're saying is that we can't really assess what this minor little word change is going to do without being able to see what the regulations are for culturally unidentifiable human remains, because they do change the purview of NAGPRA. So on the one hand, we support it and we agree and we acknowledge that it was sort of a common sense understanding at the time and that everybody agreed about it, but because the Ninth Circuit Court decision has pointed out the difference between that sort of common understanding and legislative language and legal meaning, we'd like to, ask that this be postponed until we can see what the actual on-the-ground ramifications are going to be, and we can't see that until the regulations are out. They should be out soon.
Who knows where the remains of the Kennewick men are now? Who has possession of those remains?
They're being curated and presently stored at the Burke Museum at the University of Washington, and they are under the control of the Army Corps of Engineers, which was the agency that had responsibility for the federal land where the remains were found. They were found on the bank, sort of partially submerged in the Columbia River, and that's land under the authority of the Army Corps of Engineers. So the Army Corps has authority over them.
Mr. Bender,
Senator, can I say something about the timing that Ms. Lambert is talking about? If the Ninth Circuit's interpretation of the statute were to stand, those regulations could not be promulgated, because if the Ninth Circuit's interpretation stands, remains that are not affiliated with the present tribe are not Native American materials, and the review committee and the regulations that the department is supposed to adopt are regulations only for Native American things. So I understand the feeling that you don't want to do things unless you know what the regulations are going to have. But I think the right thing to do is to change the statute back to its original intention, let the regulations be promulgated and consult in the promulgation, because if you don't do that, then the promulgation of regulations would be ultra vires, because it would be about stuff that's not Native American. and the committee's authority is only to deal with Native American things.
Well, we have some other questions. Dr. Kintig, I appreciate your being with us today, and I understand you were involved, or at least the American Association of Physical Anthropologists, the Society for American Archaeology, they were both involved in the discussions that led to the enactment of NAGPRA, and I assume there was some belief then about what the specific language meant or didn't mean, particularly with respect to the term Native Americans. Do you think was your sense that they were only referring at that point to presently existing tribes?
No, I think I agree with Mr. Echohawk that at the time, I think everyone took the definition of Native American to be self-evident. I mean, it was essentially what DOI argued in the Kennewick case. It was people we think of, just loosely speaking, it was people we think of as Indians today, and then pre-Columbian all the way back. I think that was the sort of common sense understanding of Native American at the time, and I think that's what we thought, as far as I know, that's what Congress and everybody else thought. However, as other speakers have also pointed out, the notion, there's a separation between what's considered to be Native American and what is repatriatable under the Act, and what's repatriatable largely depends upon this definition of cultural affiliation. And so much of the discussion, including ones I had directly with Mr. Echohawk, had to do very much with setting that standard for cultural affiliation. And I think what Congress's intent was to deal with those human remains and cultural items that are reasonably closely related to present-day tribes. But it did that at the stage of cultural affiliation, not at the stage of deciding what's Native American. I agree with Mr. Bender that it would affect this whole consultation process, and it certainly a benefit of NAGPRA, and certainly an intent of NAGPRA, was to enhance that consultation. I think it's been quite successful.
All right. Let me say this has been a really interesting discussion. I did want to point out Ken Davis is over here, the chairman of the Turtle Mountain Tribe in North Dakota. Chairman, thank you for being with us today. This has been an interesting discussion and one of great importance to a lot of people. We understand that. And no one would minimize the importance of repatriation of human remains, and I've talked to tribal leaders at great length about this. And there's a backdrop here in which this discussion takes place, and part of it is described by Mr. Echohawk. There were times in this country when Indian bodies were collected on the battlefield and sent back to Washington for study, and then end up as a set of bones somewhere in a basement. And that's a pretty shameful thing to have had to happen, and I was involved with respect to the legislation, the repatriation legislation that Mr. Echohawk described a bit ago, and I was involved in that precisely because this country did some things that were very shameful, and we needed to make amends for that and try to repatriate the remains to those tribes. I regret it has not gone quite as smoothly or as quickly as many of us would have liked. Chairman McCain, as I indicated to you, went down to the Commerce Committee to offer an amendment. As is always the case, wherever Chairman McCain is, controversy follows, and he seldom ever offers milquetoast amendments. So my guess is that his amendment has provoked a substantial amount of discussion. I, by the way, have left my proxy to vote against Senator McCain's amendment because we happen to disagree on this Amtrak issue. But I'm going to be offering an amendment on another bill that's being marked up just following Senator McCain's amendment. But my expectation in his was that he was going to be back before we completed this hearing. But obviously, this discussion of his is taking more time in the Commerce Committee than he expected. Let me, on behalf of our committee, pledge to you that we intend to look seriously at all of these issues. We thank all of you for traveling, in many cases, great distances to come to testify before this committee. The hearing is a hearing we held because we think 2 words or 100 words, this is important. Words have meaning and consequence. And this is not just some academic or ethereal debate. It's a debate that has great spiritual and cultural and historical significance for the first Americans, and it also has significance for our scientific community, and that's why we wanted to have an opportunity to have an exchange of views. I thank you very much for being here today, and this hearing is adjourned.